All right. Good afternoon, everyone, and welcome to today's webinar. My name is Jorge Acosta Palmer, and I'm the director of the Statewide Training Initiative with Florida Legal Services. We're excited to have you join us today for 2026 Child Welfare Legislative Update and 5-year retrospective. Before I introduce our speakers, I do want to go through some quick housekeeping announcements. This training is being recorded, so if you register, you're going to receive a copy of the recording and a link to the materials, the CLE code, all from Zoom within about 24 hours. We will also be posting it on YouTube. So in the YouTube description, you're going to be able to find all those details if you were unable to register. The training was approved by the Florida Bar for 2.0 General CLE credits, 2 Juvenile Law Certification credits. I'll announce the CLE code towards the end of the webinar. I will also drop it in the chat. It will go in the email from Zoom, and it will be in the YouTube description as well. If you need a certificate of completion or attendance, feel free to email me after the webinar is done. Usually I let some of these emails pile up so I can start hammering out those certificates. If I forget or I miss out on your email, feel free to keep bothering me until I get you your certificate because I promise I will. So I will drop a link to our monthly series that we have with Florida Children's First as well. You can find all of our recent webinars and you can find links to register for all the upcoming webinars. This particular webinar is in addition to the webinars for our monthly series. The timing is ideal because it's a legislative update. Let me see what else I'm missing. Closed captions, they're enabled for anybody who needs them. So if you're having any issues with accessibility, feel free to let me know via chat or via email. This training is being co-hosted by the Public Interest Law section. So if you're not familiar with pills, I encourage you to take a look at our website. I'm going to drop the links for our website, for our social media accounts, so you can take a look at what we can offer. This is a good time to look at the section because it's bar fee season, so you might as well consider joining the section. We have a very active, multiple active committees and work groups, one of them being the Children's Rights Committee chaired by Robin. So before I pass it over to Robin, for questions and the polls. So we're going to have a lot of polls in this webinar. So if please pay attention to the polls because we're going to be launching a lot of those. And if you want to provide additional feedback for those polls, feel free to use the chat. Now, if you have questions during the webinar, we will ask you to please use the Q&A feature. When you click on the toolbar on Zoom, you will see that there's the ability to ask questions using the Q&A feature. So with all of that said, I'm going to pass it over to Robin Rosenberg. Robin, the floor is yours.
Thank you, Jorge, and nice to see so many folks online, and really excited to be here to give our legislative update. This is an annual training we've been doing. I forgot to go back and count, but it's been for many, many years. This was a very unusual legislative session, and because of that, we are also doing a retrospective of some of the key issues and key bills that passed in the last 5 years. So I brought in my colleague, Geori Berman, our executive director, and my colleague, Robert Latham from the University of Miami Children and Youth Law Clinic, and they're going to participate with me in the retrospective part of today's presentation. Before I get started, I just want to remind you all that one of the key things that Florida's Children First does is to support the attorneys and judges that work in the child welfare system through the Florida Dependency Law Center. This is a free tool that is available to members in good standing of the Florida Bar. So if you're not already a user of the Florida Dependency Law Center, I encourage you to register. You'll get a lot of information, including things like upcoming trainings, about changes to the law and rules and other things of interest. So I encourage you to sign up. And so just to get a little practice with the poll, Jorge, would you please launch the first poll? And that's just to see like who's in the house. So by the type of work that you do. So if you would take a minute and do that poll, and I'm going to give you a second to answer the poll questions, but in the meantime, I'm going to give you a quick overview of our agenda today, which is what passed, what failed, and what happened with the bills that passed in the past 5 years. Not all of the bills, just some of the key provisions. So Jorge, how are we doing with the poll?
We are at 80% participation, so
Okay.
I think that's a good time to end it. I'm going to end it in
Great.
3, 2, 1, and end it, and sharing the results.
Okay. Lots of attorneys. Awesome. And sorry we didn't give you a selection point if you put in other, but everybody is welcome. It's great to have you all here. And thanks for practicing with the poll. All right. So what passed? I'm just going to say, holy cow. In all of the years that I've been following the legislature and looking at the bills that affect child welfare, I've never seen so few bills passed. There are just 3 bills that we're going to talk about today that affect the child welfare system. And that's just what passed. They have not all been enacted into law. So let's look at the first bill. Specific medical diagnosis and protective investigations. This bill was passed in both houses of the legislature. As of this morning, it had not yet been presented to the governor for his signature. So generally, we've only had 1 or 2 bills in the last 5 or 6 years that the governor vetoed. So you can anticipate that the bill will come into effect, but it has not yet been signed into law. This is last year was called Patterson's Law, named for the Patterson family, parents whose young, I believe twin infants who were removed for their care on allegations of serious abuse, and their claim that the injuries were caused by medical condition. And they have, I think, since proven the medical condition, but have not had the children returned to them. Their case and others like it sparked a lot of outrage in the public and with legislators. There was a bill last year that didn't make it all the way through. This bill passed pretty early on in the session. So what does it say? When there's an investigation and there are allegations of serious physical injury up front, if the parent alleges that the injuries are due to a medical condition, they can seek a medical exam. They have to offer information to the CPI about who their treating doctors, their diagnosis, who the treating doctors are. It requires CPI to request the medical records. Seems intuitive, but it is not. There have been many cases that have been investigated where the parent has claimed there was a medical condition and the CPI didn't even check for existing medical records. So this requires them to do that. It also permits DCF to delay notifying child law enforcement, at least at that very early stage. It requires the child protection teams to confer with people who have expertise in the conditions that are being alleged to be the cause of the injury. Again, would seem like common sense that they would already be doing that, but they don't always. And if this law passes, they will be required to do that. It gives the opportunity to the parents to get a second opinion exam and list who can provide that. The cost is borne by the parent, but it requires the submission of a written report and a staffing of medical professionals if there is not a uniform agreement on whether the medical condition caused the injuries. So that, and then it requires that the medical records that are generated, I believe that's by the department, have to be provided to the parents. So the folks that represent parents who have facing these accusations are happy this bill passed. They don't think they have gone far enough, but it is a starting point. So that's Patterson's Law. Passed but not signed into law. The only bill signed so far by the governor is the statute of limitations for the crime of failing to report abuse. So this is an amendment in the statute of limitations section on criminal time limitations. It refers back to the Chapter 39 provisions that make everyone a mandatory reporter and create a penalty for failing to report abuse. It extends that, makes the statute of limitations begin to run until law enforcement or a government agency is aware of the violation. So not sure in our day-to-day work how many people this will affect, but it definitely provides a mechanism to seek criminal penalties against people who covered up abuse years ago that just when it comes to light. So those were the only two bills that passed during the regular session. And we thought we were done. We were not done. In the fifth special session that the legislature held this year, they passed a healthcare bill called 5301 E that designates the fifth session. This bill passed. It has not yet been presented to the governor. There are several key healthcare provisions in it. I, again, presume that it will be presented and that the governor will sign it, but until it's signed, it's not going into law. Even though it's a healthcare bill, there are specific provisions related to child welfare that are in this bill. So the first is foster parents will be happy. The mandatory COLA, cost of living adjustment for foster care room and board rate, is a section in this bill. So you can see current until July, the current standard board rate, and how much it goes up after July 1. The next provision in here, which we're very excited about, is making the Step into Success internships a permanent program and not just a pilot. They piloted the program in Tallahassee and Orlando, very successful. It's giving young people in and just recently exiting foster care the ability and assistance to get into the workforce in a field of their interest and their choosing. So they receive a stipend. The company that brings them in receives support. The mentors who work at that company receive compensation and training. So it's very exciting. It's the young people who participated in the first couple of years super duper liked it. So it is now becoming permanent, and they've added the 5 focus counties. They added trauma-informed training. There's already an existing training program for mentors, additional trauma-informed training. And they had, in the original pilot, they had an offset. So if a young person's internship stipend caused them to lose SNAP benefits or have SNAP food stamps reduced, they could get an offset. That, I think, was an administrative nightmare. So they just upped the stipend for everybody to $17.17. I think that's about a $200 increase. So exciting provision. It also creates a new grant program for faith-based nonprofits for recruiting and supporting foster and adoptive families, but also kinship, and I think it could extend to parents as well. Not sure how that grant program or how much it'll be funded with, but it's a whole new program. And then the last thing in this bill, which I think is very interesting, is in Chapter 409, which is where most of the law governing the community-based care agencies are located. And this provision requires DCF to create a new uniform provider contract for the CBC lead agencies to use with their subcontracted providers on core child welfare services. And in Florida, core services are case management, foster home licensing, independent living, and residential group care. So currently, and since the beginning of privatization in Florida, DCF has had one standard contract that all of the community-based care lead agencies use. That contract and all of the addendums and attachments are available on the DCF website if you want to see what those provisions are. So this is now requiring the subcontracts to be uniform, and they're requiring them to put in terms like probation, termination for cause, emergency termination. And they will be required to use the standard contract going forward. So I think this is a result. I don't know what specific issue caused it, but if you've ever been involved in that finger pointing of whose responsibility is something, I mean, this is really where it comes up, right? is it the CBC's job? Is it the subcontractor's job? The CBC says they can't make the subcontractor do its job. So this is requiring standardized formatting for what those contracts are, I think, to bring greater accountability into the system. So, wow, very little that passed. I'm going to look real quickly. I think, Jerry, the pilot will continue in the existing, the statewide will continue in the existing areas. Look, see real quick in the chat.
There are two questions in the Q&A from
Yeah,
Cheryl. I can read them out loud if it's easier.
no, I
The
can see him.
first one,
I can see him,
okay,
Jorge. Can't talk about step into success right now, but happy to talk to you about it offline. And the contract will not address allowances. It's going to talk about the relationship between the parties that won't get to the level of requiring provision of an allowance to children. But good questions. Okay, so what failed? Wow, this is such a super duper long list. Um, and I don't want to spend a lot of time going through each of these items. I want to tell you why I put what failed in the materials, because many of these bills passed. Some of them passed in both houses, but not in an identical format that could be then sent to the governor. So you're going to see them again. So let's see real quickly. On this first page, I think that I don't, if I had to have made magic 8 ball, I'm not sure that any of these bills have a good prospect of passing in the future. Some of them have already been filed, and some of them have been filed more than once, so we might expect to see them again, but they had no legs. The youth engagement and allowance, that was our bill. It was really crushing because it did pass in multiple versions in both the House and the Senate, but not in the same final version. So I hope that it will come up again and eventually will pass. Um, the other bills on here, we're going to see them again. Some of them again repeatedly. Not sure there's a lot of likelihood on any of these. I know I'm going through them quickly, but we do have a lot of other material we want to cover today. So apologies for that. Lead agency subcontractor liability. This is a huge issue. The availability of insurance to all of the providers in the system is really challenging. This will come up again. It may be workshopped. Hopefully we'll come up with solutions that make sense, but that definitely is an issue that needs to be resolved and will come back. The last one on this, the extension of PES to age 26, I sure hope that comes back. This would make PES as post-secondary education services and supports. It's primarily a stipend for young people who are in college or other post-secondary school. It's available now till age 23. So there's 5 years of eligibility from 18 to 23. Lots of young people are not ready to start college when they are just turning 18. So this bill would have made those 5 years flexible, either in and out over that course of time, or to start later and end at 26. It was a great bill. There was a lot of support. I was very sorry to see that it died. Temporary custody is going to come in and out, and we're going to talk more about the changes that have already been made and how that's going. Recording, I mean, I think you'll see more and more endeavors to get parents' rights enshrined in legislation, especially during investigation. So we've seen some bills in the past. Expect to see maybe some in the future that might go forward. That last item, child welfare safety training, is part of that liability insurance issue that is definitely coming up again. The last one is the step into success that made it into the health bill. So I've jammed through a lot of material. Is there any time frame in which the CPI has to get the medical records? I think, Stephanie, I think there is. I do not have detailed knowledge of it. There will be uh, information if you want to look at the bill. The bill number will be in the materials. So sorry, I can't answer that question. All right, is there anything in the chat for me to address? Okay, I think I made my time. We're going to start our 5-year retrospective, and I'm going to turn it over to my colleague, Robert Latham.
Hey, Robin, are you in charge of the PowerPoint?
I am.
Okay, great. So I am going to take us on a brief tour of some bills that passed over the last 5 years. I'm going to start with two of them before handing it over to Geori, I believe. I'm not going to go into the level of detail Robin did on the new bills because these are bills that have been in effect for a while. And you probably have a lot more experience with them than any of us could have predicted at the time they were passed. So the first one we're going to look at is SB 80 from 2021. And 2021 was COVID. We were all on computers. Stuff was, going on. And in the middle of all of that, the legislature passed a sprawling overhaul to how child welfare foster care placements are handled. So what was the purpose of this bill? Several purposes. First was, well, a main purpose was to promote sibling connections. So it added a lot of provisions explicitly to protect sibling bonds, to ensure sibling communication and visitation in ways that prior to this bill, we had to cobble these together from other provisions and make arguments. This made it very clear. So that was wonderful. It attempts to improve placement stability in lots of ways. It created a lot of new mechanisms and safety mechanisms and procedures that have to happen before a child in foster care can be moved, including requirements around placement transitions, MDT staffings, and the potential for court hearings to challenge placement decisions when children are being moved, whereas before it would have been almost solely up to the discretion of the Department of Children and Families. Now you do have some paths to getting in there and getting an actual challenge to it. You talk more about that. And then a big part of it was to comply with some federal laws that had been on the books for a while, ensure funding and other things kind of were in place for a lot of these changes. So let's take a look in a little more detail. So SB 80, what changed specifically? So it took the multidisciplinary teams that existed already in different places in the statutes for different purposes and consolidated a lot of them into one main MDT staffing, supposed to be held by trained facilitators. The main purposes are around placement and education, but we'll talk more that there are other triggers for these staffings as well. It created very detailed transition plan requirements. We are not supposed to be moving kids willy-nilly in the middle of the night anymore. We're supposed to be deliberate. We're supposed to be thinking through the contingencies and making sure they have maintaining their connections and they're able to maintain their stability through all of this. We can talk a little bit about whether that's happening. I said already a process for sibling placement. There were a lot of rules that went into effect that are meant to promote siblings being together. And it just overhauled the placement process at statutory level just completely. It just got the legislature much more involved in how placements are made. Whereas before, the protections were really on the high end of the placement. So SIPs, residential treatment centers, placements on that end of the spectrum were already highly regulated. This created more procedure at the regular foster home level that we really hadn't seen before. It created a priority placement list, which we'll go over in a second. It created explicit factors for placement decisions as opposed to just a blanket best interest test. It created presumptions for kids that it's in their best interest to stay in their placements after 9 months of being there, and it gave limited standing to caregivers to challenge the placement changes. And then that kicks off an entire bonding assessment hearing and even a potential appeal. We can talk about that after that. So this is just night and day from what we had before, which was essentially nothing. Robin? So the placement priority list, those of us who have been around a long time are used to thinking of the permanency goals as ordered, reunification, adoption, guardianship, etc. But this SB 80 created the same type of priority system in placements. So we should be thinking of them, placements for kids in this order: non-offending parent first, relative caregivers, adoptive parents of siblings, fictive kin, non-relative caregivers, then licensed foster care, then group or congregate care. So building this into our, our analysis, our workflow, the same way we do the permanency goals, is going to be really important to making this law come to life and actually help kids. I can't say, I mean, we'll get to my opinion later, but I can't say I've seen a lot of that analysis happening in the same way we go down the permanency list, but I would love to see more. Robin? The grounds for placement changes were limited by SB 80. Kids should only be moved if the caregiver is clearly unable to safely or legally care for the child. Reunification is the reason. If it's to further permanency in some way, so a move towards a more permanent placement, or if it's just demonstrably not in the child's best interest to remain in that home. And we could think of lots of reasons that might be true. But it also required services to stabilize placements. And again, this was done piecemeal and kind of at the discretion of the agencies who wanted to preserve certain placements before. But this now gives you a little bit more of a statutory hook to demand services to stabilize placements, and for placements to demand services to stabilize themselves, right? Because the caregivers usually know what's going on in their houses and what they need. Robin? Got it twice. In case you missed it the first time, or did we go the wrong way? There we go. All right. So it also added, SB 80 also added placement consideration factors. So a whole other statute with just a list of best interest factors that are supposed to be made by the CBC, the case management agency, the court, and essentially everyone. And the factors are not surprising: the age, the benefits to the child from either staying or moving, stability and longevity, bonds, reasonable preferences of various people, impacts on relationships, changes in services in schools. I love number 12, impact on activities important to the child. So is this move going to take them out of a thing that they absolutely loved? We need to consider that. Impact on public benefits. That is now an explicit thing we should be considering. Are we moving them out of eligibility for independent living or other programs? That's something we should take into account. I will note that this is 14 factors. The manifest best interest factors for termination of parental rights only has 11 factors. So this is a lot to consider, and it's supposed to be done. At every placement change and every placement consideration. Robin? Okay, so the MDTs are the other big change here, and they're convened on placement changes in physical custody, changes in educational placements, but also on placement decisions impacting sibling groups. And then the statute says any other important decision in the child's life, which is so complex that the department believes that it's necessary to convene this MDT. And so the point of the MDT is for the department to formulate its position. This is a way of I think one way of viewing this is it's a way of the department reasserting itself back into these types of decisions that were before this largely made on the ground. So DCF has added the following important decisions to the list through the regulations: locating and placing missing children, there should be MDTs for that; human trafficking placements, there should be MDTs for that; reunifications, there should be MDTs for that. I know that's a sore point in a lot of places because those can slow things down. And reinstatement of parental rights. It's rare, but it does happen, and there should be MDTs for that according to DCF's regulations. And again, remember, this is not a court process. This is to help DCF formulate its own opinion. And Robin, the next slide. If there's consensus in the MDT, that consensus is binding on DCF. Let me repeat that. If there is consensus in the MDT, that consensus is binding on DCF and the CBCs. So all you lawyers out there, and I saw a lot of you on the list, go to the MDTs and build a consensus. It is binding on DCF and the CBCs. This is an advocacy point that I think a lot of us are missing, and you definitely want to be there. I know that I'm going to get things in the chat about you're not invited, and you have to figure that out locally. But this is an incredibly important place of advocacy. Binding on DCF is powerful. If there's no consensus, then DCF's position is determined by DCF. There is no reg or CFOP right now that designates who that person is, but I did call around and ask. I'm told it is currently the child protection director in each region. So there is an actual human being who will resolve the non-consensus. So again, this is DCF reasserting kind of its role in these low-level placement decisions and other decisions for kids. Whether that's good or bad, we can talk about. Robin? All right, so we're gonna do some polls really quickly. Jorge, do you have these?
Yes, I have them ready, but before I launch them, Robert, we do have a few questions in the Q&A. So I figured I would ask you the questions out loud, and then I will launch the poll so people can answer while you answer.
Let's do it.
So the first question is, how can we use SB 80 when CM doesn't comply? The next question, I'll repeat them just in case. The next question is, does the priority placement list create a requirement for a diligent search? And the third question, do they need MDT for overnight stays with parents going towards reunification? So when I go ahead and launch the poll, it has 4 questions. So
Yep.
Robert, I can repeat the questions just in case. I'm gonna go ahead and launch it now for people to answer. So go for it.
All right, so my poll questions to you are really just to get a gauge of how you're seeing these things play out at the local level. So go ahead and answer those. I'm going to try to remember those questions in reverse order. So I read you the list that DCF has created by regulation. It was the original statutory list of reasons for an MDT, and then plus those extra 3 or 4 on that slide. So overnight visits is not on that list. I don't know that if DCF versus CBC wants to hold an MDT staffing to talk about something, I don't think there's really any way to stop that per se. It may be a helpful tool in some cases, especially on contentious cases, but there's nothing in the regs or the statute that I see that would require it for overnight visits in all cases. Jorge, I've now forgotten question number 2, so I apologize.
All right. So question number 2 is, does the priority placement list create a requirement for diligent search?
There were separate requirements for diligent searches that I can pull and we can call me separately and we'll talk offline about the details for diligent search, but those have always been in the statute. And you should be using those separately, especially if it's going to tie into the priority placement list, right? So if there's some of the saddest cases we ever, I shouldn't say that. Some of the most frustrating cases we ever deal with are the ones where kids were adopted by a family and then DCF did not reach out to that family, right? And then we get a lot of inter-family and inter-adult conflicts over a new child that comes into the system. So the diligent search process and keeping in contact with prior families is incredibly important. And Jorge, number 1.
And the first and last question is, how can we use SB 80 when CM doesn't comply?
Right. So SB 80 and the provisions in it, most of them are in fact mandatory. So you do have some space to go into court and get a judge to order them to comply. Just a regular Chapter 39 kind of injunctive order, ordering them to do something they're required by statute to do. There are a lot of SB 80 though that are discretionary. So you have to hold the meetings, you have to consider the factors, but at the end of the day, it's still going to be a discretionary decision. And remember, most of what I talked about was about DCF creating its position. On most of those critical life events type decisions, you're still going to go in front of a judge. You're still going to have your motion and your hearing there. So I've heard stories of DCF saying it needs weeks and weeks and weeks to do, to formulate its position by holding these MDTs. They're in the statutes. There's provisions that say they can't delay these meetings just because somebody can't be there. They can't delay these meetings waiting on evaluations. These MDTs are supposed to happen quickly. And I wouldn't wait weeks and weeks and weeks, I still go to court and set my motion just like I would. And if DCF doesn't have its position, well, that's DCF's, issue to deal with. But again, if you can get consensus in the MDT, that could be a great advocacy strategy. So it really is case by case, and I'd love to talk to you individually about that if anybody wants to call. All right, Jorge, how do we do on the poll?
Right, so we have like 58% participation.
I'll take that.
We've
I'll take
had it
that.
for over 3 minutes, so I'm gonna go ahead and end it and share the results. So let me know if you can see
Yeah.
the results.
Yeah. So how often are the MDT staffings being set? Often, or about a third of us don't handle cases. So all right, so they are. I'm gonna take this as, yeah, you are seeing them. And then how often or how useful do you think they are? How useful do you think they are? So somewhere between sometimes and often, a little split right there. So not a complete wash. Um, are custodians using their rights? We're getting some sometimes on that. So, okay, the legislature will be happy to hear that it, shouldn't be every case, right? But it should be sometimes. And then a trick question: are kids more or less stable now than they were in 2021? About the same, is we're leaning towards about the same. So let me go ahead and finish up. Robin, I'll do my last two slides on this section and then do my next section really quickly. So according to DCF's dashboards, no, this did not have a demonstrable effect on placement stability or siblings being together. So, and I want to give a caveat on that in a second. So I know it's hard to see on Zoom, but on the right, that's placement moves per 1,000 bed days. 2021 is the beginning of that chart. You see placement instability went up for a little while and it came back down. So, that happens. So we can't say that the MDT staffings didn't help this. It may have been much, much worse during that time. Who knows? But the MDT staffings in and of themselves don't seem to have moved it demonstrably down. And then on the left, that's the percentage of sibling groups placed together, and that has just steadily trickled down. Another thing to keep in mind is the child welfare system in general is about 40% smaller than it was back then. So our out-of-home care population has shrunk. So that could be playing with these numbers as well. But we're not seeing large moves in these numbers the way we might expect. All right, Robin, I'm going to do my last slides in 2.5 minutes, I promise. All right, the next bill I'm going to cover is SB 1224 from 2024. This one I'm doing just because it's near and dear to my heart. Was a Robin, we can go ahead and move forward. Was a revamp of the guardian ad litem model slightly. What was the purpose of it? I couldn't tell you, other than I'll quote Stafford Beard here, that the purpose of a system and government systems is what it does. So let me tell you what it does. 1224 renamed the guardian ad litem program to the guardian ad litem office, kind of rebranding it as a statewide office instead of the local programs that we used to know and love. It allowed the guardian ad litem director to be reappointed without having to do an additional search every few years and having to be reconfirmed and all the process that has to go through that. Remove some mandatory requirements on training, so the GAL office has more control over its own training. Require the GAL to assist in the recruiting and training attorneys ad litem, which I found really interesting. Role changes. The biggest thing it did was mandated guardian ad litem appointment. It was no longer if the court could or if one was available. It's a shall now. So that's an interesting change. Authorize the guardians ad litem, specifically their attorneys, but maybe others, to represent kids outside of dependency court, kind of what the traditional attorney ad litem would do in Medicaid and public benefits cases. Define the guardian ad litem as a fiduciary using a best interest standard, so bakes into the statute the type of advocacy that the guardian ad litem has to do. Historically, it's always been best interest, so that's not a huge change. But if a future director wanted to take it more of, kid-directed model, that would be probably cut out from under them if they wanted to go that way. And broaden the term guardian ad litem to include a lot of people, but specifically the statewide office. So this is another example of kind of Tallahassee and the statewide offices kind of getting more control over the local offices a little bit more. So the statewide office is explicitly listed in the definitions now as part of this conglomerate known as the guardian ad litem. It added a bunch of actions for the guardian ad litem and granted the guardian ad litem and attorneys for the kids as well, I suppose. Immediate and unlimited access to the kid, to the children, which was already in the statutory goals for Chapter 39, but this made it maybe made it a little more enforceable. Robin will take my next slide. I think it's just questions.
And I will say, people have started to make comments in the chat, which is great. We wanted you all to do that.
Yeah. So I'll take a look at those. So Jorge, we'll pop up the questions for everybody as I talk through the chat.
Going through it. So I'm going to read out the message in the chat for the benefit of the audience. There's a comment. I think a provision should be that GALs be required to speak with parents if they're available. I rarely, if ever, have the gal talk to my clients' parents, but they are making recommendations on the BI. I just don't get that. And there's a reply saying, agreed, we run into this issue often. There's a couple of reactions. I guess now the chat shows the reactions. There's another comment on 2021. MDT was worse and scattered in meetings. Perfect storms came together. Inexperienced judge seated 5 days. CLS attorney 6 months after. Oops, another one came in, so I lost it. 6 months after bar passing bar. Caseworker hated her job and only took job as a paycheck and wanted out of a highly complicated case. Gao new case after leaving job as same marked worker, no AAL, was awarded to adjudicated children.
Yeah. So for Deborah's point, I mean, the point of the MDTs was to bring together experienced people and bring the whole team together into one space and one place to have these conversations. So hopefully that stabilized decisions a little bit more. The MDT model is used in lots of areas of law. So for sure, it has, multi-decade history of being used in really complex settings. As far as the guardian ad litems, they're supposed to do a full investigation. One of the changes was they're not supposed to just investigate the petition anymore. They're supposed to investigate all aspects of the child's best interest. Meeting with parents absolutely should be part of that. It's not statutorily mandated. Defense attorneys, parents attorneys for sure need to try to facilitate those connections wherever they can. That can be incredibly important advocacy. But I worked at the guardian ad litem office for years, and I can tell you it's a blind spot, right? And it's definitely something that needs some encouragement. How do we do on the poll, Jorge?
So we have 49% participation. So I can go ahead and close it out in 3, 2, 1, and ending it and sharing the results.
All right, describe the changes since 2024. Oh no. Okay, so I'm getting a minority on better, but about the same and worse. How common are the guardians ad litem in your area, or volunteer guardians ad litem? About the same. Okay, well that's good to hear because there was some concern that this was a model change to push towards a more staff-centric guardian ad litem office, and this is good to hear that that's not the case. How often are guardian ad litem attorneys talking to the kids on your cases? And I'm getting a little mix on that. So that unlimited access statutory provision caused some skirmishes between the attorneys already appointed to those kids because there are bar rules about attorneys talking to other people's clients, and we need to sort that out so we can stop having those fights and get back to advocating for the best interests of kids. But for now, it seems to have settled down a little bit. Except in the chat, I'm seeing that maybe it hasn't. So reach out to me separately if you'd like to talk about that. It's certainly my position that I want guardian ad litem attorneys to talk to my clients. I just want to know about it and have a little bit of control over that and not be surprised later about what they talk about. But the bar rules are pretty clear that attorneys for a party need permission from another attorney to talk to their client, and that's been my position the whole time, and I think that should be everybody's position. Robin, I ran over time. I apologize about that. I think, oh, sorry, I do have 2 more slides. I'll quickly do these. There were budgetary changes.
You have 5 minutes. You're good.
I am not overtime. Great. There were budgetary changes at the guardian ad litem office as well. They did receive more money for salaries and benefits to try to improve retention. They also tried to expand their attorney base a little bit more. Here's some comparisons of their budget from 2021 to 2025, and you'll see that the majority of the changes have been around salaries, benefits, OPS, and that sort of thing. Next slide. I got the personnel records from them back in 2020. I got the personnel records from them in 2025 and just took a look at the head counts and the average salaries and turnover, et cetera. I'm not sure they're stabilized yet. So attorney average salary went up about 32%, which is fantastic, but the tenure, the average amount of time that an attorney has been at the office went down from 5.1 years to 4.5 years. I'm not sure that's a significant jump or a significant dip, but it's not the direction you want to see. They did move a lot of the CAMs, the CAM 2s or whatever the title was back in the day, into an assistant circuit director kind of position. So they created a little bit of middle management, but it justified raising some salaries and keeping people around longer. So it's probably a good idea. In general, though, the CAMs on average have only been there for three and a half or so years, right under 4 years. Statewide leadership's been there for 15 years. This is, I guess, how government agencies work. Average 5-year turnover, though, is pretty high all the way across the board. That's about 17% a year, which in government work is pretty high. So still have some work to do to keep people around. But I guess trying to head in the right direction. I believe that the guardian ad litem program is incredibly important for the best interest of kids in our state. I believe they need good people. They need institutional wisdom and knowledge and people that'll stick around there. So I hope that they're able to get there. Robin, go ahead. So, I mean, that's my perspective, right? I do not want to see the volunteers go away. I think they're the heart and soul of the guardian ad litem model, and for sure, have way more time to spend with kids than your average attorney who's in court. I'm concerned because I have heard statewide that there is a push for the attorneys to visit the kids X number of times per month or quarter or whatever. I've heard different things. That requires time, and I made the move from guardian ad litem attorney representing an organization or a volunteer or whatever, however you want to view it, to having a personal relationship with a client who is a human being who has my cell number, who texts me at 3 o'clock in the morning sometimes about things. And that's a completely different model of lawyering that requires significant support. And I'm not sure they've received it yet, and I hope they do in the future. I haven't seen a lot of attorneys from the guardian ad litem office representing kids outside of Chapter 39, but that is something I would love to see more of. But to have it happen is going to require lower caseloads, more attorneys, less court time, more support for that outside advocacy. And that's what I hope I see. That turnover rate is concerning to me. This is my perspective part. I get to talk about what I think. I'm still concerned about the turnover rate. I really want to see people make it there and be able to make a career out of it. But that's just not possible with with the current salaries or caseloads from what I can tell. And Robin, one last slide. Has the representation rate changed over that time? I don't know because the guardian ad litem office took down its regular representation rate measures. So they used to post them, how many volunteers they had, how many kids they were representing. That was pretty standard to post, and that was helpful. They don't post that anymore. So except for their annual reports, it's really hard to tell. So we don't know if the expansion in salaries, et cetera, and kind of the kind of refiguring that configuring that they've done has had a change in the number of kids represented. I think it's probably close to 100%, but if that's because a CAM is handling a caseload of 150 kids, I'm not sure that's better, right? So we really do need to think more about that. I think that's it. Did we have any questions in the chat that came up in my last?
Yeah, your time's up.
Yep.
So if you want to look at chat and respond to that, there's been great conversation, and I'm really pleased that everybody is doing that. But we do need to move on to Geori's section. So,
all right, take it away, Geori.
Hi, everyone. Happy to be here. My name is Joy Seldine, and I'm the Executive Director of Florida's Children First. And in that role, over the years, I've worked closely with Florida Youth Shine, which is Florida's Children First is youth advocacy organization, which is completely youth-led of young people ages 13 to 26 that were in foster care or experience homelessness or the child welfare system. and we're all around the state. They identify legislation every year and they go and they advocate to legislatures, and they've been extremely successful with legislation, anything from normalcy to extending foster care with keys to independence, a lot of different really great legislative changes. So I'm going to talk about two of those legislative changes and then actually a third one that came that are really youth-centered bills. So if I can go to the next slide. So one that is very exciting and near and dear to my heart, it took about 5 years for Florida Youth Shine to get passed, was Florida Youth Shine's priority of rights education and educating young people about their rights and the laws and in place to protect them, because there are some really great laws that we're talking about, and we believe that knowledge is power and that our young people should really know about those rights. So what is the purpose? It's that all children will get age-appropriate education about their rights. The DCF will work with the young people to develop the materials, and it also creates an Office of the Ombudsman to assist youth with their concerns. What did the legislation do? So it amended 39-40-85, which requires case managers to educate children about the laws and requirements on several key topics, which I'm going to talk about in a moment. And then it also codified the Office of the Ombudsman through DCF. That was effective in 2023, which is important to note when I do my reflection. So how does that need to be delivered? So those instructions and information on the laws and requirements should be provided to a young person upon entry into care, when they initially come into care, then every 6 months, and at every placement change. Also, that information needs to be made understandable in a manner that is most effective for each individual child. We know that someone that is 15 might not have the same understanding as someone that is 6, but they all need to be able to get that information. And they also need the opportunity to ask questions, which we know is important. And the provision of the information, it needs to be documented in court reports and in case notes that they're receiving that information. Next slide. Now, the creation of informal material. So DCF must consult with young adults and youth in creating and revising the information. So the documents that they're using to explain the laws to young people they need to be created with our young people. And they also must use any feedback to ensure that the information is understandable. And I will say that they did that. It took several years, but that document is recently out, which I'm going to talk about in a moment. Now, what are these key topics that I'm referencing? There's a lot of topics, everything from nurturing care, personal safety, to normalcy, education, participation in court proceedings, permanency planning, other case planning. You can read them all here, placement, visitation, as well as like access to food, clothing, shelter, and healthcare. And these were some of the key topics that were most important to our young people when they were writing the legislation. Next slide. So it also codified the Office of the Ombudsman. There was an ombudsman before, but there was no requirement in law or procedure in legislation. Now, what does the Office of the Ombudsman do? They receive complaints from children and young adults about placement, care, and services, and they're supposed to be mediating concerns. They are to be a resource to identify and explain relevant policies and procedures to children. And this was an interesting approach, that they're also supposed to make recommendations to DCF to address systemic problems. So if they're often hearing a complaint about something, they need to address that and make recommendations to DCF. Next slide. So I'm not sure if you've ever seen this document. It was recently released. It took several years, but it is now accessible on the website. I'm going to put it in the chat, as well as the information for the ombudsman. Let me put it in the chat right now so you guys have it. But on the left, that's a picture of the cover of the document. You may or may not have seen it. I'm going to ask you in the poll in a moment. And then there's also the information for the ombudsman that you can contact. Now, this document is specifically for 14 and up. There is a document on the website that is for under 14, but that is not updated. That has not been updated since the law was passed. Next slide. So I have my poll now. So we want to know, have you seen this document that I just showed you before, the new 2026 one at least? How well do young people understand the laws in place that impact their lives? And before today, did you know how to direct a young person to the ombudsman?
Right, we're close to the 1 minute mark and we've had over 50% participation. So just give everybody a few more seconds
And
and
if you
I'll
want to put
close
any
out the
discussion in the
poll.
chat, feel free to do that as well.
Oh, yeah. And I'm closing it in 3, 2, 1, and sharing the results.
Thank you, Jorge. Ooh, so no, you have not seen the document before. That's not surprising to me because we just found the document on the website about a month ago. It really wasn't distributed. How well do young people understand the laws? It looks like a little, which is progress. We're hoping as the document gets distributed and folks are in the field showcasing it that our young people start to understand that better. And then, did you know there was an ombudsman? Most people did not. So now you do and have the contact information for them. Next slide. So what's my perspective on this? My perspective is that it's very powerful, the legislation, but it's under construction for implementation. Then there is a new document, like I said, that was just released. It took 3 years for DCF to finalize that. Fortunately, they did consult with the young people to create that document. So it's something that you, Shine, and the young people that worked on it is very proud of. But there isn't a document for under 14 that has not been updated. So hopefully that will be out soon. There is no training program yet. They have not implemented how they're going to be training the case managers to distribute that document. And my other, as the poll showed, is that the ombudsman needs to be publicized more. They just put the ombudsman under the behavioral health department. That's all new. And clearly, they need to be publicizing that there is an ombudsman to young people more so that they're utilizing it.
Jory, there's a question about whether the caseworker is supposed to provide a copy of signed visit notes. And I'm not sure if they mean if they're supposed to note that they provided a copy of the document in their visit. I have not seen any regulations on that or practice. So if anybody has experience with that and can answer in the chat, of course, it's best practice that if the law requires you to do something, to do it and to document it. I'm not sure if there's a specific requirement that they do that. So,
Yeah, that's what I would say.
yeah. Okay. Oops.
And someone put in the chat, are they talking about the last page in the package? So the young person is supposed to sign that document that they received it also. So moving on to Florida Youth Shine's other priority that passed in 2024, and that was the expansion of aftercare services. Now, the aftercare expansion, the purpose of this was to make aftercare available to youth who were previously excluded. We were hearing a ton of issues on young people who were adopted or placed into guardianship or emancipated prior to 18 or in a certain placement, like a relative or non-relative that wasn't licensed, and they didn't have access to any services after 18 if they ran into an emergency or just, having to navigate adulthood. So as long as they were placed by the dependency court into out-of-home care for 6 months or more after they turned 14. So we wanted to make it eligible to them. Now, what is aftercare services and financial support? We often think of it as financial support when they're needing emergency financial assistance to overcome barriers to self-sufficiency, but there's also a lot of other supports available, whether that be for tutoring or mentoring or parenting classes and life skills or job training or financial literacy skills. So these are all the things that aftercare services can include. Next slide. So who is eligible for aftercare? So previously, it was young adults who were previously in the foster care system if they were between the ages of 18 to 23. And now it includes that they were placed by the dependency court into out-of-home care for 6 months or more after 14. And either they turned 18 when they were still in out-of-home care, they were adopted, they were placed into guardianship, or were emancipated. Now, out-of-home care includes youth that were placed in foster care and those placed with relatives or non-relatives. So that was really big, whether they obtained their foster parent license or not. So it really expanded the pot of young people that could get this service, especially if, for instance, they were adopted and didn't have any support anymore from their adoptive parents and ran into a pickle. Next slide. Who is not eligible still? Young adults who were previously in the foster care system and were reunified with their parents prior to 18. We tried to get this passed, but it did not work. And young adults who were in the foster care system but left before 14 or did not spend 6 months in out-of-home care after 14. So, what has been your experience? Did you know that aftercare was made available to more youth in 2024? And do you know any youth who are getting aftercare support now that they weren't eligible before? If Jorge, you can launch the poll.
There's a couple of things in the Q&A. There's a question about whether info will be shared with the guardian ad litem. Mario, are you referring to the information? I'm not sure what information you're talking about. So if you could revise your question, we can answer that. And then I think Deborah answered one of our questions. When a caseworker with the CBC visits the children and kinship, they, I guess they upload the signed visit notes. So.
All right, let's see. We are at about 46%. There's been great conversation in the chat, and I wanted to add to the audience that what I'll do is I'll save a copy of the chat and I'll add it to the materials in case you missed any of the great conversation happening in there. Somebody asked if this was being recorded, and yes, it's being recorded, and it will be posted on YouTube as well, and the email will go out from Zoom. So we're about the minute mark, over 56 percent. So I'm going to go ahead and end the poll and share the results.
So let's see. Did you know most people, well, the majority, some people knew, but the majority, 57% of you did not know. So that's a change that hopefully now you know and you can access those services. And did you know any youth who are getting aftercare support now that weren't eligible before? So only about 14% of you have utilized it so far, and most of you said not yet. So now that you know, we'll hopefully see if there's something that you encounter, your young people can absolutely access it. And someone said, is this aftercare the same as extended foster? No, they're two different programs. Aftercare was always around. It's not new, but this just expanded the eligibility. So what's my perspective? I think it took a bit for folks to find out about it, and obviously folks are still finding out about it. When we first encountered it, right when the law was passed, they were getting denials for eligibility. However, we just sent them the law, and now we haven't had an issue. Now, the last one that I'm going to talk about briefly is expansion of PES, EGAP, and EMAS and those services, Extended Guardianship Assistance Program and the Extended Maintenance Adoption Subsidy, and then PES, Post-Secondary Educational Support and Services. Now, what was the purpose of that? And that was to make those programs available to more youth by including those who exited care at 14 instead of 16. And that was going alongside aftercare. So that was an initiative DCF was working on that we worked on and supported as well. What does this do? It increases the population of youth for post-18 assistance by lowering that age from 16 to 14. And that includes extended guardianship assistance payments in the case closed to guardianship after turning 14. It includes the extended maintenance adoption subsidies if the case was closed to adoption after 14, and then post-secondary education services and support if the cases were closed to either adoption or permanency. Sorry,
about that.
Adoption or permanent guardianship after 14. So we want to hear about your experience too. Have you had any young people that you work with who are now eligible when they lowered the age to 14? And Jorge, if you can open that poll.
While we wait for people to answer, there is another question in the chat. I'm not sure if it's a question or a comment, but there's a caseworker is supposed to share. However, CVC has a narrative to set, and we have seen serious delays and withholding notes and information from GAL and CLS attorney.
Thank you. And it looks like Yolanda asked, is there a future plan to lower the age for services again? As far as Florida Youth Shine is concerned, they have not identified that as a priority for this year. I don't know if there is on DCF. Sorry, go ahead, Robin.
I was just going to say the other part of that is the funding for a lot of these expansions are tied to CHAFE and the federal funds requirements. 14 is really the age.
Yeah.
It's all driven by federal money.
Yeah. And there is a lot of CHAFE reform happening right now on the federal level. That's a whole other training, but none of them would reduce the age to that.
All right, so I'm going to end the poll and share the results. There we go.
So 46%, sorry, 42% said no. Somebody said not sure. And then yes was 26%. So a good amount of folks since it's been lowered. So thank you for sharing your input with that. And if you have any other information or input that you want to share, you can put it in the chat. Next slide, Robin.
I think I put it up there.
Oh, sorry. So how is it being implemented? I think it's we've seen that it's currently being implemented and helping young people. So it's been a success so far for those that are eligible. Robin?
Thank you.
I'm going to turn it to Robin for your turn. I don't think there's any questions left.
Okay. And thanks. Really appreciate everybody's participation in the chat. Okay, so I'm going to wrap it up. I didn't have a good theme for my topic and just called it odds and ends. So the first odds and ends we're going to talk about is turn my video back on. Temporary custody. And the purpose of changes to Chapter 751 were to expand and give fictive kin the ability to obtain custody in family court. So for many years, Florida had the ability for a relative to a certain degree to be able to go into family court. Very easy if there was agreement with the parent. I took custody of my teenage nephew because he couldn't get along with his mom and dad, and we both agreed he could try living at my house. Went to court, easy peasy, 751. There are also more contested 751s where grandma's been taking care of the kid for a long time. Mom and dad are in and out, maybe not doing so well. And grandma really needed the custody to be able to take care of the kid. We had 751 all along. But what if it's Aunt Betty, your mom's best friend who's always taking care of you, but is not legally related to you? So expanded, give fictive kin the ability to obtain custody. And it added best interest language. And I want to be clear, directed at providing for transitions when children are returning to their parents. So going back to Senate Bill 80, we don't treat children like potted plants. We have transitions for them. If they've been with a caregiver for a long time, we need to transition them properly to the next place they're going to be, even if that is their parent. So in the bill that passed in 2020, this is exactly what it did. It permitted fictive kin, and it added best interest considerations. If you read it, it says to protect minor children by allowing transitions consistent with their best interest. It permitted discussion of best interest in the petition, but also specifically referencing transition as well as other things, and permits the court to give reasonable transition conditions. So if you remember 751, parents have custody of their children and the legal right to their children unless the court takes it away. When there's an agreement and when there's a quarter of temporary custody, it's largely premised on the parent's agreement. And when they withdraw that, they have the constitutional right to their child unless the court intervenes and removes that. So it was it's that balance of parental rights with taking care of the best interests and needs of the children. So this was changed in 2020, 6 years ago. I think folks have seen experience with how it's working in fact. And so, Jorge, if you would launch the poll on temporary custody. Want to know what you think about the changes. And given what the changes are, who have they helped? You should be able for that one to select multiple choice. Is it helping the caregivers? Is it helping children? Is it helping parents? Is it helping the state? And I also have a question about whether your CBC lead agency offers legal services to help people get temporary custody, because we think we're seeing it being used more and more as a diversion tool, so that instead of bringing children into a shelter status, they're helping the family hopefully resolve its own problem using a 751 as the mechanism. So there are some CBCs that fund the legal services for the petitioner for 751. So I'm curious to know whether your CBC does that or not. How are we doing on the poll, Jorge?
We are at 42%. So I can end it in 3, 2, 1, ending it and sharing the results.
Okay. Okay, so it's pretty mixed across the board about the changes. Good and great are the majority though, so that's good to know. And who have they helped? Good, there's a view across the board, so not too terribly skewed. So thank you all for your input on that. And then, so interesting, it might be something you want to inquire about in your community. Is your CDC participating in it? So let me tell you my perspective on it. I think the fictive kin provision is working well. It's helping make those relationships and get formal custody to people who are taking good care of children. I am very concerned about the use of the best interest language. I have seen 751 petitions that have safety plans or conditions for return written into them, and I do not think that was the intention of the ability to use best interest standards in a 751 petition. There are CBCs that are funding legal services that are putting those conditions for return in. I think that is very concerning. I think it creates what is nationally known as hidden foster care, which means children who are eligible for services from the child welfare system. We always want the family to be able to take care of itself with assistance instead of bringing children into care unnecessarily. I think that's hugely important. But when it is done in a shadow process where people do not have good due process, they're not provided with legal representation, or they get insufficient legal representation, that is of a great concern to me. So when we do 751s, sometimes the investigator or CBC may direct them to a local legal aid program. I think my colleagues at legal aids across the state do a great job for the caregivers that are seeking 751s. They've been doing it for a long time, and they know how to help their clients get benefits if they're need benefits. But a lot of these are being done by paralegals who are not taking on the full representation of the client. They're doing the petition basically at the behest of the child welfare system to keep the kid out of care, as opposed to providing full and competent legal representation to the caregiver who is the petitioner. And in all of these processes, neither the parents or the child get legal representation, and children don't get a guardian ad litem. And so it's a very one-sided process, which is very concerning to me. And the consequence, and a lot of this of going into a hidden foster care situation, is the caregivers may not have adequate support to meet the needs of the child. So the child's needs aren't getting met, and the caregiver is under great stress, taking on a big job without adequate support. And it's very concerning. And then at the end of the day, the parents have a hard time getting their child back because they don't have an attorney to go help them petition for the return of their child. So I have a lot of concerns about how this is happening. It's not unique to Florida, but I think it's very problematic in Florida.
Well, we have a few questions related to 751 before we move
Okay.
on to the next one.
Sure.
In the Q&A, we have, does this 751 include FSS licensed kinship caregivers rights?
751 is different from licensed kinship caregivers. 751 is a family court proceeding. It can be done in a dependency court. In some places, they are physically handled there, but it's a family court procedure that grants either custody or shared custody to the caregiver that is completely separate from kinship caregivers that are licensed by DCF. Yes, parent has to be notified in a 751. They have to be, they have the opportunity to be heard, but there is no statutory or other right of appointment of counsel for them. So they are often unrepresented in it. And I agree, there's serious deficit in representing and legal guidelines to representing caregivers. So that is very interesting because we have legal guidelines for the attorneys that represent children, and we have guidelines for the parent attorneys that represent parents, but we don't for caregivers, and that's a good thing for somebody to work on. So thanks for raising that. Very awesome. Okay, I'm going to go to my next topic, which is BQRTP, which sounds like a burp to me. Behavioral Qualified Residential Treatment Program. A BQRTP, they were created for the purpose of accessing federal money to pay for group home placements. The federal government stopped paying generally for children to be in group homes. One of the exceptions was for children placed in a qualified residential treatment program, which is a residence which provides therapeutic services. The federal government had a list of compliance requirements, and essentially they were in Florida very similar to the requirements that we have in place for qualified residential, therapeutic group homes. So when Florida wanted to change and access that funding source, they created qualified residential treatment programs. Created them in 2001, but the scheme they used required those programs to have an ACA license, and very few facilities became qualified residential treatment programs. So they wanted to make it easier to put children in therapeutic group homes, and that's what this bill did. Those create homes for children that have behavioral issues that make them hard to place. So here's what the bill actually did. It defines therapeutic group home. This is in 39407. It changed the requirement for qualified evaluators, which we've always had for residential treatment. It moved the entity that housed them from ACA to DCF. It created two types of credential for qualified evaluators. There's one level for residential treatment centers, and then there's a separate level for therapeutic group homes. So I always go back to this very unpretty Venn diagram about what we're talking about when we talk about a residential treatment center. Residential treatment center is the overarching term that encompasses SIPs. Those are statewide inpatient psychiatric programs. Those are locked mental health facilities. Florida also has therapeutic group homes that are residential treatment centers, and a subset of those therapeutic group homes are qualified residential treatment programs. Separate from them now are the BQRTPs, the Behavioral Qualified Residential Treatment Program, which are not residential treatment centers and therefore are not governed by the laws that govern residential treatment centers. The difference in the evaluators is that when they're doing evaluation for the therapeutic group home, they can be a licensed mental health counselor, not just a psychiatrist or psychologist. They can have 1 year fewer experience than making evaluations for therapeutic or residential treatment centers. The reason to place a child in the BQRTP does not require formal mental health diagnosis. It can be just emotional or behavioral. And placement can be made in a BQRTP prior to court approval. A hearing has to be held within 60 days after, but prior approval is not required. So had BQRTPs in place for a few years. Would love to hear your experience. Jorge, if you would launch the poll. So if I'm just looking at the Q&A, if there are competing caregivers for a 751, those individuals, so there's a petitioner, it's family court. The proposed caregiver is a petitioner, the parents are the respondents. If anybody else wants to try to participate, they would have to intervene in that proceeding. DCF has no authority to determine between competing caregivers. They can pick a caregiver to support if the lead agency wants to fund a petition by one of them, but it is a family court decision, not a dependency court decision that a DCF attorney has the authority to make an opinion on. So Cheryl, your question about denial of RTCs. I understand that there has been a recent change to the payment rate, increasing it, that should, in theory, bring more placements online. I'm not sure if that's SIP only or if it is also therapeutic group homes. I just heard about it the other day, but the hope is to raise the rate and bring on more providers to make more availability for young people in need. So Florida is creating a BQRTP. I'm not sure what your question is about that. Okay, how are we doing on the poll?
We are at 43%. It's been almost 2 minutes, so I'm gonna go ahead and end it in 3, 2, 1, ending it and sharing the results.
Okay. That's a real mixed bag. It's unfortunate because if there's going to be a residence intended to provide behavioral support and it's not working, that's very unfortunate. And I don't know, folks, when you don't know the quality of the evaluations, is that because you're not seeing them or getting to participate, or just maybe not having to work on them at all? Yeah, okay. 11% of you think the BQRTP admission process is fair, of those that have any information on it. So it's a little more than not fair. So very interesting. Well, here's my perspective. We've been waiting for DCF to issue guidance to the attorneys on how to handle the BQRTP hearings. When they were first created, DCF was using a parallel process to QRTPs. What they did for QRTP, they started doing for BQRTPs. That has changed over time. And in my communication with colleagues in different parts of the state, how those hearings are handled seem to be different. We've asked DCF about a policy, and they have not at this time issued one. So I think it would be helpful, for the department to issue more clarification on how it wants BQRTPs to operate. And, for all of us, for all of you who are representing parties in the system, to understand what's going to happen, how they're going to process those hearings. And then, ultimately, if therapy is not being provided that's helpful to kids, then it's just another way to, create a loophole to drive a truck through to make the federal government pay for our group homes that aren't helping kids. So if they're there, we want them to help kids, to be useful. Perhaps with some rate raises, we'll see better outcomes from kids. I don't know. Kind of unfortunate. Okay. Let's see, is there a question? All right. I have a few minutes to do my last topic. Denied adoption applicants. Okay. Purpose of the law change that we're going to talk about was to shorten the time between the termination of parental rights and the finalization of adoption. When there are competing adoption applicants, prior to the law change, a denied applicant could have an administrative hearing at the Division of Administrative Hearings. And I think then it actually was moved to a DCF administrative hearing. um, and then could go to court or go to the appellate court if they wanted to challenge the outcome. So this is data that DCF provided to the legislature at the time it sought the bill change. There's a big chunk of time being taken up, delaying adoptions, and they estimated the change in the law would decrease that time between TPR and adoption by 116 days. So it eliminated Chapter 120 hearings, required the dependency court to review the denial of an application to adopt, and prevented somebody from filing a petition to adopt unless either they have DCF's consent or a court order finding that they unreasonably denied the application to adopt. So set out the new process with timeframes for the denied applicant to challenge the decision, to let the court then know they wanted to challenge the decision. The statute created standing for the denied applicant to make a motion and present evidence, and says the standing ends on the entry of the order. The approved applicant, because this is a competing position, has the standing to participate in that hearing and can be heard without filing a motion for leave to intervene. So set out the standard of review as an abuse of discretion, and then specified what the court could consider. And then the issue of was the denial consistent with the department's policies, right? So that could be expansive. There's a policy, not just a policy, there's a statute that requires that the department engage in family finding from the outset of the case. So if the department fails in its job to do family finding for 2 years, and then at the time of TPR finds a relative who would like to adopt, has it violated its policy to do family finding, which is extraordinarily important in the issue of who's going to adopt the child. That issue was addressed in a 6 DCA case, which determined that the policies that the court can review is limited to policies related to the denial of the adoption petition. Very narrow ruling in the 6 DCA. Department is very supportive of that position. Lots of other folks think that's too narrow. And the really interesting thing is, what are the policies related to the denial of an adoption petition? It's kind of almost impossible to find out because the department refuses to provide discovery. So this was a big issue. It was an issue at the outset. This is the slide that we created the year the bill was passed. The term discovery is not used in the statute. It was previously available. Discovery and due process were available when there was an administrative hearing. Specific records were automatically provided on request in the administrative hearing process. That process doesn't exist anymore. Does the right to access that discovery still exist? I personally think due process compels it. But department continues to fight that and to claim that not only is there no right of discovery, but the minute the court issues its decision, there is no right of appeal. And that's just, again, a violation of due process, right of access to courts. A denied decision can be appealed. So those issues are really being litigated presently in the in appellate courts. So I'm going to ask you all for your experience. I see some chat is going on, but Jorge, would you, issue the poll on your experience with that? Let me look and see if any of these are questions that I can answer. Let's see. Let's see some discussion, but not questions in the chat. So give it a minute to get your experience. So
There was one question in the chat, Robin. It's if you are AAL, should you participate in hearing?
100%. Who is the most affected person by that decision? It's the child. It's where the child's going to be for the rest of their life. I mean, I don't, they're a party to the case. Yeah. My colleagues who practice in that day to day may have differing views on that, and I would love to see that in the chat. But I'm representing a kid, and this is going to impact their life and their future. 100% I want to be in that. Okay, attorney should be in the ARC. And the bottom line is how does the ARC, how does the judge make a decision about what's best for the child unless all the relevant information is presented and considered? So, okay, Jorge, how's the poll doing?
So we're at 30%, so I'm gonna go ahead and end it. It's been over
Yeah,
almost 2 minutes, so and let's
Yep.
share the results.
We are out of time. Are they so sometimes more ending more quickly? A lot fewer think it's more fair. And okay. A lot of y'all agree that the ARC process is a mess. I think it was a mess before. And I think it's a mess still. So I'm just going to end with, we have one last poll. If you will stick around and give us an idea of what other training topics you have, we super appreciate your participation. I'm going to say that on behalf of Geori and Robert and myself. We're available to talk to you offline if there are issues that came up that you want more input on. And as always, we thank you for your participation. Next week, next Wednesday, my colleague Dayna Maeder is going to be doing her presentation on preserving the record for appeal in Chapter 39 cases. So it should be a concern for everyone, and I hope I see you there. And if not there, at the Florida Bar meeting in Orlando. So thanks, everyone.
Thank you everybody for joining us. So thank you, Robin, Gory, and Robert. So we'll see you at the next one. Bye.